So as I've said, my name is George Sismy-Darrant, an associate at Brodie's in the planning team, involved in CPO stuff, and I'm joined today by Karen Hamilton, who's a partner in our Glasgow office in the planning team, Elaine Farqhuarson-Black, who's in our Aberdeen office as a partner, and Scott Logan, who's in our real estate team, the legal director. So we're gonna get cracking with the meat of today's session. So I'm just going to start and ask each of you if you could kind of, obviously you're involved in different aspects of CPOs and compulsory purchase work. So if you could each just go around the table and give us a kind of a snapshot of how you're involved and kind of what you do in compulsory purchase.
Okay, thanks, George. I'll kick things off. I cover the property aspects of our CPO projects, in the main acting for local authorities and public bodies doing promoter work. I will often be involved in the early stages of a project doing the land referencing work. So that's basically to identify all owners, occupiers, and other parties that might be affected by the proposals. So land referencing really plays a crucial role in the CPO process throughout. So it's obviously important that all affected parties are identified at the outset, but also at key stages going through the process. So that facilitates engagement with affected parties throughout the process and also protects the acquiring authority against any challenge for any procedural challenge, for example, for failure to notify at a later stage. Moving on to the next stages of a project, I'm often involved in preparing the compulsory purchase order and the statutory notices that go with that, and arrange for service of the statutory notices and advertisement of notices in the local papers, etc. And then moving on to the kind of tail end of the acquisition process, assuming all good and the CPO is confirmed, I will then usually take the lead in the post-confirmation and vesting procedures. So again, that involves preparing the relevant documentation, preparing statutory notices, and arranging for service on affected parties, and again, advertisement in the press as required. As for the sort of projects I'm involved in, I tend to deal with a lot of roads projects. So certainly over recent years, we've had a number of significant roads projects that we've been involved in, but that has evolved slightly in recent years. So we are assisting local authority clients with CPOs in other areas, for example, housing and regeneration schemes.
Okay, well, I'll maybe jump in now. So like Scott, I'm largely involved in promoter work, and Scott and I are often working together on CPOs made by local authorities or other public bodies to deliver a particular project. I tend to get involved in drafting statement of reasons, which is the document sort of setting out the justification for the CPO. I can also be advising on compulsory purchase powers and choosing between different statutes when sometimes there's a choice for clients as to the route they want to go down. Could be responding to objections or preparing and presenting cases at inquiries if there are objections to the CPO. And like Scott says, probably most of our CPO work was transport related going back a few years, but we're seeing a much broader mix of projects now relying on compulsory purchase powers, so including housing, regen, active travel, heritage even, and energy projects. So it's becoming, I think, increasingly an issue for those. Both, I suppose, under CPO and way leaves, although we're not talking about those today. But so it's a great mix, certainly keeps things interesting. Over to Elaine.
Well, I suppose I probably found more on the other side of the fence. And whilst I do some, kind of acquiring authority work, I'm mostly acting for landowners whose land is either under threat of compulsory acquisition or way leaves, as kind of Karen mentioned there. And so the work for the landowners might be at the beginning part of the process, so it's objecting to the scheme, or advising on blight. Obviously, when the routes are published, and what does that mean, and what action, if any, can they take? you know, right through appearing at any, you know, kind of inquiry or hearings into the objections. And then at the later stage, once it's been confirmed, that's submitting claims for compensation. And a lot of my work is on the compensation side. So it's submitting applications to the Lands Tribunal where there has not been agreement reached on the amount of compensation that should be paid for the acquisition. And again, in that, a lot of the ones that and the claims that I deal with, and obviously George, you know, you've been working with me, you know, on those. It's to do with the planning element, and it's to do with establishing what would the position have been in the no scheme world. What would we have been able to get planning permission for another type for a development that's been prevented for the scheme, and obviously that impacts significantly on the amount of compensation that the person would receive. So it's often said that, you know, we live in the hypothetical world quite a lot, George, in terms of, you know, sort of imagining what it would have been if the scheme hadn't been there. Still wearing the kind of developer landowner hat, I also act for developers where they might be doing back-to-back agreements with an acquiring authority. So where they're actually doing a scheme, but they need land to be compulsory acquired for that to be completed. And in that case, I would be working alongside the acquiring authority. And so I said in that one, I'd be sitting on the fence rather than being on the other side of the fence. I'm sitting on the fence. So again, covering all the different types of schemes that both Scott and Karen have mentioned.
Brilliant, thanks very much. So just picking up on something you said, Karen, about you're seeing CPO being used more across a broader range of development types. Are you, and it obviously sounds like and Brody's are busy on various different things, but do you think that there's been an increase in the use of compulsory purchase powers? And I suppose with being on the planning hat on, do you think that's going to be more likely given the infrastructure first approach in National Planning Framework 4?
Yeah, it's an interesting one. I mean, certainly we, I think as a team, feel we're doing a lot more on the CPO front. And you're right that in terms of NPF 4 and the focus on infrastructure, I mean, undoubtedly it's going to be, you know, continue to be a sort of growing issue, if you like, going forward. But according to the CPO register, which is maintained by Scottish Government, I know a lot of people listening will be aware of that, there hasn't really been any sustained increase in the use of CPOs since around about 2012, which is the year when the data on that CPO register sort of properly starts from. And it is surprising, I think, given the work which Scottish Government has done over that period, really to try to promote the use of compulsory purchase powers, you know, in appropriate cases. So I've done a bit of sort of rough analysis on the figures on the CPO register, and I mean the numbers average around about 15 CPOs per year that make their way as far as Scottish Government, so being, you know, put forward to Scottish Government for confirmation. So between say 2012 and 2022. There have been particular spikes within that period. So if you can imagine, you know, projects such as the A9, which as we know was split up into sections with a CPO for each of those sections. But it's really, those numbers aren't large if you consider there are 32 local authorities in Scotland. We've got the park authorities, various statutory undertakers, and, you know, multiple other sorts of bodies that have compulsory purchase powers. So I think really what the stats are showing is probably what we might have guessed, in that those authorities that are confident in using the powers are continuing to use them. So it's probably not a surprise, but those authorities who just haven't been familiar with them, perhaps don't have that confidence. I mean, many local authorities in Scotland haven't made a single CPO during that sort of 10-year period, which I think is, you know, quite remarkable. Transport-related CPOs definitely still the most common, but we're seeing reasonable numbers both under the housing legislation and planning. So that just gives you a bit of a sense, I think, of what's going on.
Brilliant, thank you. So we talked about compulsory purchase being used for site assembly, and kind of especially when you're dealing with some of Elaine's clients who don't want to give up their land or want an extortionate amount of compensation. But If you, we understand you can use it for other types of title issues. So Scott, perhaps you could give us a few examples of where compulsory purchase could be used in that context.
Yeah, certainly, as you say, George, compulsory purchase is a very effective site assembly tool, and in particular when it comes to resolving tricky title issues. So one of the key benefits of compulsory purchase, and in particular taking title using the general vesting declaration procedure, is that the acquiring authority acquires good title to all of the land that is covered by the CPO and the GVD. So the GVD will cure any defects in titles. So for example, if you've got gaps between the underlying titles, or if there's overlapping titles and competing titles and the like, that's all cured by the GVD process. GVD is also good at dealing with other kind of conveyancing difficulties. So for example, if you've got an owner that would otherwise be unable to convey a property because of some incapacity, for example. So GVD is great for doing that. It also provides a solution to other difficulties. So for example, if you've got potentially problematic title conditions or servitudes affecting the site, the default position is that the general vesting declaration will extinguish all title conditions affecting the land. So that's set down in legislation, and the procedures have to be followed. So all affected parties that would otherwise be able to enforce those conditions have to be notified, but provided that is complied with, then all title conditions will be extinguished. Compulsory purchase also allows the acquiring authority to acquire tenancy interests that might otherwise be difficult to acquire. So for example, if you've got land that's subject to a secure agricultural tenancy, or in residential context, if you've got residential tenancies and the grounds for termination would be difficult to satisfy, so CPO provides a route to acquire those interests there. Similarly, looking at the position with lenders, you don't need to be overly concerned about lenders' interest there. GVD allows the acquiring authority to proceed and acquire good title to the land and take entry and commence works, and basically deal with the lender's interest at a later stage. Their interest is still protected, but really only becomes relevant when it gets down to discussing, negotiating and settling the compensation claims. And then perhaps finally, but by no means least important here, is the ability to deal with unknown and untraceable interests. So that's often a problem with compulsory purchase. If an owner can't be found, or their present whereabouts are unknown. So CPO and using a GVD again provides a procedure to acquire those interests, and it is essential. And it's going back to that point I made about thorough land referencing. Provided that's all been carried out and can be documented, then that shows that the acquiring authority has carried out reasonable inquiry to ensure that everybody that has an interest in the land is notified. And if after those reasonable inquiries, the address of an owner cannot be identified, or the owner itself can't be identified, as sometimes happens, then there are procedures which allow for service of notices on owners, occupiers and lessees at the property address, or indeed by erecting conspicuous site notices on the land. So yeah, various different title issues that can be solved using the CPO process.
That's great. Thanks so much, Scott. So I think a bit about the process. I mean, you said Scott said at the beginning about how he was involved at through the process at the various stages. There's a perception, I suppose, that compulsory purchase takes a long time. Without saying the answer, it depends. Is that correct? And do you have an average time scale for us?
I'll start on that one. but I think everybody needs to be seated comfortably while I talk you through this the particular one. If I'm acting for a developer, you know, when we discussed before in terms of a developer might need you know, a piece of a road or something, or land for a road, and you often talk in a planning inquiry or the planning application stage, or there's always compulsory purchase powers. It takes about 18 months, you know, 2 years. Allow for that in your kind of build program. Sadly, my experience is that is, you know, often optimistic, and, you know, Scott and Karen might have different experiences. But if we look at the one that I've been spending a lot of time on, obviously I feel like most of my working life has been involved in the Aberdeen Western Peripheral route. You know, that's the 46 kilometres dual carriageway that, you know, now goes round Aberdeen and through Aberdeenshire to try and take, you know, vehicles through away from the city centre. And they first started looking at route in 1950s, and I've now just thought, now that I've said I've been doing this most of my working life, most of you will think I was already working in the 1950s, and I wasn't. However, they then in the 1990s, they kind of refined and looked at more route corridors as a trunk road. And then in 2003, the Scottish Government decided they were going to take it over, and it was going to become a trunk route. And then they did yet more corridor studies. And you remember when I was talking about, you know, acting for the landowners and being, you know, potentially under the threat of blight and all these routes and different options. So there were more, and the final route was selected in December 2005. The draft orders were published in 2006, 2007. The inquiry into the objections to that took place in 2009. The order was made in 2010. It was challenged, albeit unsuccessfully, in court. The land vested in the Scottish ministers on the 11th of January 2013, by the time they'd gone through, you know, all the processes that kind of Scott described. And then construction of the scheme commenced, and the road finally opened, you know, completely on the 19th of February 2019. And claims for disputed compensation need to be submitted within 6 years of the general vesting date. So they needed to be submitted to the tribunal before the 11th of January 2019. So actually before the road was fully open, you had to submit your claims for compensation. And as you know, George, because you've been working with me, you know, we are still in the process of, you know, going through those claims at the Lands Tribunal. So, you know, that's 10 years after the land vested. And, you know, it's, you know, almost another 10 years, you know, after that or before that, that they had kind of started the process. So if you're looking at averages, then my experience of the AWA is going to push your averages so high. It's unbelievable. But I'm hoping
we should leave the AWPR out of the average calculation.
I'm hoping, and I know it's like that. It's like that Section 75 agreement that takes forever and pulls the planning authority stats, you know, kind of way down. So I'm hoping that the two of you are going to be able to give us hope that actually they're not all like that. And that was
Scott's got some much better news.
Yeah, no, I'll jump in with an example at the other end of the scale. So this is much speedier than the AWPR. So assuming, of course, that you can take the inquiry process out, obviously, if there is an inquiry process, that will certainly add a considerable period into the programme. But assuming there is no inquiry process, it is possible to complete a compulsory purchase order start to finish within a year of the decision to proceed with the CPO being made. So we were involved in a city centre roads project a few years ago, and yep, start to finish, that was the timescale set, and we're able to push that CPO through within a year, which was pretty good going by my reckoning. Particularly as it was taken forward during the first full COVID lockdown. So there were various practicalities around serving notices and making documents available for inspection that made matters rather tricky in that event. But it wasn't without its challenges as well. There were a number of objections made to the CPO. So there was a process of having to manage those objections out, but that was done and inquiry process avoided. So that was a good news story on the timescale front. I thought I'd also just pick up here on the timescales for dealing with the vesting procedure. So again, all going well, and you've got a confirmed CPO, we would normally factor in about 4 months to complete the vesting procedures. So that takes account of 2 minimum statutory periods which have to be catered for. So first of all, there's a 2-month notice period before a GVD can be made following confirmation of the confirmation of the CPO and the notice of intention to make a GVD. And again, once the GVD actually has been made and the various notices served on affected parties, there's a further 28-day period before the land can vest. So that's 3 months taken up already. But again, various documents need to be prepared and various notices need to be served. So yeah, you'd be doing very well to do it in under 4 months, I think.
You've just pulled the average back, though. I'm impressed. Impressed. Going way down.
I think that's right, and it's important. I mean, when it comes to things like, well, actually the time taken to vest, because when an authority is saying, well, when can I literally get onto the site, it's the whole thing you need to take you need to take account of. But coming back to Georgie's, it depends. I mean, clearly a number of factors are going to influence the length of time that the CPO will take. So in some cases, there can be quite prolonged discussions between the acquiring authority and objectors before the CPO case would be passed over to the DPA to arrange an inquiry, and that may be at the authority's request. If they see that there are reasonable prospects of, resolving objections, then they may think, well, it's worth investing that time and sort of pausing the formal proceedings before bashing on with those. Obviously, that can make quite a difference to timescales if you're doing that over a number of months. And as Scott says, the format of any DPA process, whether it's your full BUNA, PLI or not, perhaps even some kind of written submissions process, that will make a big difference. It's also worth remembering that there's no set timescale for the ministers to make a decision on a CPO once they have the reporter's recommendation. We like to optimistically think that will take a couple of months following the reporter's recommendations being issued, but it certainly can take longer, and especially if the case is a bit controversial, we do find that it can take a while to get the final decision out of the ministers.
Presumably, depending on how many land interests are affected, it's going to have one of the biggest impacts on the timescales, because as you say, in terms of there's a bigger possibility of people objecting, which would then trigger all the other kind of processes as well.
I think that can be the case, although what you may find is that for all you may have quite a number of objections, if they're all largely sort of raising the same issues, it's not necessarily a sort of linear thing, but absolutely, the more kind of complex the project, you would expect it to take a bit longer.
Grand. So it depends. Spot on. So moving on, a lot of when you think of compulsory purchase, you obviously think of public projects like AWPR or down south HS2. But as was mentioned earlier, it can be used to facilitate private development, or at least development in the private sector, such as house building. So just could you say a bit about when that might be possible, and kind of what should a house builder, for example, do if they want to explore the use of compulsory purchase powers?
I think, George, it depends on what you're needing to do. If you like, as Karen kind of mentioned earlier, various bodies have statutory powers. There's a whole bundle of acts that actually give compulsory acquisition powers to various bodies, and one of the first things you got to do is make sure you use the correct act. So you need to know the purpose for which the land is needed. And then we've got the general power, again, that Karen mentioned in the Town and Country Planning Act, which is, for acquiring land for development or redevelopment, which is in the interest, of the proper planning of the area. So that's a kind of nice, quite catch-all one. But you would generally use that as the kind of fallback. There might be, the more specific one. So if you were looking at housing, as I think I mentioned before, you might have at one end of the scale that I, as the house builder, need a piece of land to be able to, implement infrastructure. That I might need a bit of a road or whatever. And then generally the house builder would try to reach agreement with the landowner, and if that's not possible, look to the planning authority to come in, or the roads authority to come in and assist in that regard. At the other end, and again we've talked about it, but it was regeneration. So I've been involved in the full-scale regeneration of existing housing schemes. And that's often, with housing associations. So, for example, I was involved at Anderston with Sanctuary, housing association, and that was done. That's one of these ones that I mentioned before, where it's done with a back-to-back with the council. So you're working very closely, with the council, and the compulsory purchase came into it because a number of the units within, the blocks had been bought under the rights to buy. Over the years. So you've got, whilst the housing association has, the bulk of the properties and could therefore do what they want with them, there's the other owners whose interests, needed to be acquired, and they weren't able to reach agreement with some of the proprietors, and that was preventing the whole scheme and therefore preventing the regeneration of that, that area of Glasgow. And so the council used its compulsory purchase powers to acquire, those interests, so then that the development, the existing units could be demolished and then rebuilt, all up to the kind of modern standards. Now there was a planning inquiry into the planning application side, so Sanctuary got the planning permission for it. There was an inquiry into that, and then there was a separate compulsory purchase inquiry into the objections that remained outstanding from the compulsory purchase kind of point of view. So again, back to what we were talking about before in terms of the timescale, it wasn't very quick. And so, you would need to, house builders would need to, bear that in mind in terms of the speed and, kind of what's involved. And then bearing in mind that in that scenario where we've got that back-to-back or agency, kind of agreement, the developer is picking up the acquiring authority's costs. So picking up the council's costs for promoting the scheme and going through the scheme, and then ultimately the compensation that's paid, to the landowners, that's coming from the developer. And the one thing that I always want to remind people is that the fact that the land is being acquired, compulsorily, doesn't change the fact you've got to pay market value for it, and that works from both sides. So you've got the landowner looking to get more and thinking they can hold out for more, in terms of, like, if I use that Sanctuary one, thinking they can get more, but they can only get market value, for it. And equally, the developer needs to pay market value for the land, and that can include a ransom value, so that if that land or property is needed, and there's no other way to allow the development to proceed, then the market value includes a ransom payment. So those are all things that have to be factored into, I suppose, when you're thinking about that going forward with a compulsory purchase scheme.
Great, thanks very much. So you've said about, obviously there's various routes to getting a compulsory purchase, but in terms of once the CPO has been made by, let's say, the local authority, it then obviously has to be confirmed by Scottish ministers before the powers can be exercised. And what sort of things do the ministers take into account when kind of deciding whether or not to confirm a CPO?
Obviously, they take into account any objections that are being made to it, and there's no grounds, there's no standard, we don't have statutory grounds for objecting to a scheme. But in terms of what they're looking for from the acquiring authority, the compulsory acquisition is justified by necessity. There needs to be compelling evidence that that land is needed in the public interest for the particular purpose that it's being sought, and the onus is on the acquiring authority in those circumstances to demonstrate that acquiring the land is proportionate. So they'd be looking for a clear statement, and normally that clear statement would come out with the order in terms of explaining why it's needed and why that land is needed to enable the project to go ahead. There's no obligation to obtain planning permission before you go down the compulsory purchase route, but it is helpful to show that the approved scheme needs the land. As I say, the example that I gave previously of the one at Anderston, there was the planning permission that had been granted, and it showed, obviously that it was going to go ahead. And I suppose viability comes into that as well, in terms of looking that, the scheme is going to go ahead, that there is, funding arrangements, because you wouldn't want to be depriving somebody of their land if there's no prospect of it actually kind of proceeding. And the ministers will look for evidence that you have tried to reach agreement to acquire the land without having to go down the kind of compulsory purchase route first. So all of that, you know, in terms of the what Scott was describing and Karen describing before, that's a lot of that is done before you get into the process. The actual meat of serving all your notices, you need to make sure you've got that kind of all that evidence in play, and that's something, Karen, that you would be very familiar with.
That's right. These are exactly the sort of issues that an acquiring authority will be addressing in the statement of reasons that it has to prepare, coming back to that, and it's the sort of work that's done in preparing that helps the authority sort of test its own case, if you like. Human rights considerations also come into play, and the proportionality of impacts on affected parties. So that's really, you know, looking at a balancing of adverse impacts that people will suffer as a result of the CPO, but weighed up against the public benefits of the scheme. And that's particularly relevant where existing homes may be being acquired, as is not uncommon, particularly for the sort of regen scheme that Elaine was talking about. You know, with the sanctuary example, we've also got a couple of similar schemes on the go at the moment. And I'm sure going back a few years now, people remember the CPO for the Commonwealth Games Athletes Village that Glasgow promoted, and some of the controversy around that. We ended up with a documentary on the television looking at some of the families that were affected. But in that sort of case, a lot of emphasis will be placed on rehousing strategies. So in other words, what arrangements are the acquiring authority putting in place, or at least offering to affected parties to try to mitigate that impact. And reporters and the ministers will also be interested in just potential barriers to the scheme coming forward generally. So as well as consents, as Elaine has mentioned, or it could be other regulatory processes. So for example, if a stopping up is required or something like that. But the good news is for acquiring authorities that the CPO circular of 2011 does go through all of these matters in a really helpful way for, you know, an authority that's not familiar with the process. It sets out very clearly the sorts of issues that they should be trying to address in the statement of reasons.
Okay, that's a very helpful point. So when it's at the decision, we're aware of some CPOs not being confirmed. I'm sure many on the call will be aware as well, of some down south, and also one involving Fife Council recently. Is there anything we can learn from those? Is it, for example, getting harder to obtain approval or confirmation from the ministers in Scotland?
I think certainly in terms of those English cases that you mentioned, George, there's been quite a lot of discussion in I won't say the compulsory purchase community about these cases, a lot of blogging done about them. One of them was known as the Vicarage Field CPO. If people want to have a look at that, that was in the London Borough of Barking and Dagenham. And the second one related to what's called the Nicholson Shopping Centre in the Borough of Windsor and Maidenhead. Now, both CPOs were recommended for refusal by the inspectors following inquiry. The Vicarage Field CPO probably primarily failed on viability grounds, but in both the cases, the acquiring authorities were criticised over a lack of engagement with or support to affected parties, partly coming back to relocation strategies in the case of the Nicholson Shopping Centre. And it was felt that insufficient negotiations had been attempted with landowners before the CPO was progressed. Now, certainly these cases do sound, I think, a cautionary note for authorities generally, but it does seem to be the case that more emphasis is placed on efforts to acquire in advance of CPO by the English circular. And so it's certainly possible that reporters in Scotland may not have taken quite the same line. And I'm aware that I think at the Nicholson's case is being appealed at the moment, the Nicholson's shopping centre example. The Fife case that you mentioned is also interesting, and as you know, Brodie's were involved in that one on behalf of the landowner who successfully resisted the CPO. And now the background is quite complex on this one. If anyone's particularly interested, they can have a look at the reporter's recommendations on the DPA portal. You'll see there's a fairly deep dive into issues such as industrial land supply, as well as really quite a detailed assessment of the council's policies and how they should be interpreted. But ultimately, the reporters there, they were satisfied that the land in question was suitable for the use that was proposed by the council, but the reporters felt that it had not been established that the land was actually required for that use. And so the test under the planning legislation, it was a planning CPO in that case, was not satisfied. So again, a bit of a cautionary note, and having a scheme that's recognised as being a worthwhile scheme, unfortunately, isn't in itself sufficient to justify a CPO, but it's worth remembering that overall the percentage of CPOs which are refused does remain low, and so acquiring authorities shouldn't be put off from considering using their powers where it's felt that there is a compelling case and that they can support that through a robust statement of reasons, which really is what it's going to come down to.
Okay, grand. Thank you for that. So shifting perhaps to more of like the landowner's perspective rather than the acquiring authority. I suppose perhaps more Scott from the process or Elaine from compensation side. What do you think acquiring authorities could perhaps do better when it comes to kind of mitigating impact on affected parties?
I think first of all would be recognizing the kind of human element. Compulsory purchase is about, allowing development which is in the wider public interest, to proceed. But you have to remember it's depriving somebody of their land. And most people, we get to choose when you want to sell your property, and you don't choose to sell it when, we're at the bottom of the market. You might want to plan with your estate planning, tax planning when it's a convenient time to sell your kind of property. Well, you don't get to do that if your land is earmarked for compulsory acquisition. That the ability to do that planning and decide when you want to sell it, is removed. But aside from that, in the practical sense, there's it's an emotional impact, especially if it's your home. And as I talked about before, in terms you could have, route options hanging over you for a number of years, and having that threat, is it going to be acquired? Is it not going to be acquired? Takes a huge toll on people. And that's, of course, before you find out years later how much compensation you're going to get, for having your land, kind of taken. And it might not be at the level expected. So I suppose I would be saying, to acquiring authorities, plea to kind of acquiring authorities is to decide the route, if it's a route thing, decide it as, quickly as possible so that people aren't under the shadow for so long. Listen to landowners' concerns. If I go back to the AWPR, we had discussions to say most of my clients weren't objecting to the principle, but they were saying, could you put it around this side of my farm building, or could you put it, and if you don't do that, then they object, kind of obviously. So listen to landowners' concerns, keep the timetable, kind of as short as possible. Scott's obviously outlined how quickly he can do it. So, we need to get that kind of done quickly and pay up quickly. I'm the chair of the Compulsory Purchase Association in Scotland, and I sit on the board of the national body, National Compulsory Purchase Association, and we have a mental health working group looking at the emotional impact of compulsory purchase on both sides. Also on, because equally, while I'm talking about the landowner, there is a mental health toll on people, from the acquiring authorities' point of view, dealing with people's emotions and knowing how to cope when people are phoning you up, kind of concerned. And looking to see whether well-being can be built into compulsory purchase schemes going forward. How could that be done? But what I would be saying is you don't need statute, to change behaviours and to have that kind of empathy, I suppose, in terms of when you're dealing with people's property, people's lives. So I suppose it's that side, George, from my point of view.
Yeah. Just before I jump to Scott, I saw an article about a guy with HS2 whose land was being acquired, / he had to leave his home, family home, etc. And obviously now HS2, this north bit has been canned. So how his life's been completely ruined by it. But that's an aside. So Scott, have you got anything from your perspective?
Anything positive?
Just, I guess one thing to add what Elaine was saying, I think from a landowner's perspective, it's really important to document any agreements that are reached with the acquiring authority, so that there's a clear record of going forward of what has been agreed, and whether that relates to accommodation works or other mitigation measures, or whether that's in response to objections made to the CPO or other representations made as part of the ongoing consultation. So however that arrives, whether it's kind of formal undertakings or whatever, it's very important that a landowner has a clear written record that they can rely on in the future. Obviously, a lot of these projects run on for many years. Elaine's projects run on for many years, and obviously over that period, particularly with acquiring authorities, but also with owners and claimants as well. If it's organisations, there will be changes in personnel over time, and what was agreed by the manager or whatever a few years ago, they've moved on. That might all be lost, that knowledge might be lost. So it's very important that there's a clear record of matters agreed and discussed. And that can be as simple as just accurate meeting minutes being prepared and agreed by both parties at the time, or it can be, at other end of the scale, it can be contractual contracts drawn up by the respective parties' solicitors. So yeah, no, very, very important there. And I guess also, I think it assists parties on both sides as well. If the acquiring authority has a suite of balanced templates that it can use for things like voluntary purchases, licenses to occupy, and things like that.
Excellent. Yeah, that's really helpful.
Sorry, George, I was noticing that a few questions had come in. There was one on surplus land, which was perhaps slightly tying in with your point about HS2, but might just pick that one up now, or any of the other questions that you were looking at. We could perhaps pick up a couple. But I mean, the handback of surplus land is something that pops up quite commonly as an issue, and I think the questioner is saying, well, for example, with a TS scheme, land acquired, scheme built out, there is surplus land, but what are the obligations? I mean, this is something which is sort of regulated, to use that word, by the so-called Critchell Down rules, and they're set out in one of the Scottish Government circulars on compulsory purchase. But the rules are essentially that if land has been declared surplus, and it should be offered back, but a person who's been affected in that way can sort of prompt the process by asking the question, is the land surplus, and making it known that they would like it to be handed back. But there is a framework under which that would happen. So if it's to be offered back, it will be at market value at the date of the offer back. And there are various exceptions. So if the land has been changed in some way, then there isn't an obligation to offer it back, and there are various exceptions relating to things like size of the land, and if you're not the original landowner but are someone who perhaps succeeded to, let's say, a farm that was the affected land holding, that's exempt. So it's a kind of complicated area, but it is set out, the rules are set out under these so-called Critchell Down rules, so that's something that it's worth people having a look at.
You're on mute, George.
Thank you. Yeah, cheers. So we've got to 1 minute overrun. So we did have one more question about reforms, but perhaps we'll wrap it up there to kind of on that note. But just want to say thank you for the three panelists today. If you found today interesting and you want to find out more, Elaine's already mentioned the Compulsory Purchase Association Scotland. You can also join, if you're a slightly younger generation, Compulsory Purchase Association Future Scotland. And then also a big announcement, Brodie's are going to be going forward producing a compulsory purchase newsletter, and that'll be coming soon. So if you do want to be added to the mailing list to that for all the juicy topics, then please contact Lee Peddy. Her email's on the slide, and you should have got the invite from her as well. So yes, I just want to say thank you very much for coming, everyone. Thank you for Scott, Karen and Elaine for your very helpful insights, and hopefully it was useful to everyone else. The next event will be Thursday the 30th of November. It's with Craig McLaren, who's the National Planning Improvement Champion. So that'll be really interesting. So hopefully you can join us then. And once again, thank you very much for joining us, and see you soon.
Thanks, everyone.